Welcome, everyone. It's great to have you here at 4IP Council's webinar on OSS and FRAND-based standardization. My name is Jillian Murch, and I'm a Senior Director of Government Affairs at Qualcomm and a member of 4IP Council. And I will be your host today for the webinar. As many of you know, 4IP Council is a not-for-profit research organization that focuses on the link between IP and innovation. And the Council's mission is to identify the most relevant topics in the space and to produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you will find plenty of free materials, for example, studies and guidelines, summaries of relevant papers, and recordings of our webinars. We also produce easy to digest content, especially tailored for non-IP experts, SMEs, and startups. And we really do this because we want to encourage them to find ways to use IP to further their businesses. I'd also like to mention our new podcast, which is called IP Stories, where we interview entrepreneurs, inventors, and IP disseminators to unveil stories behind intellectual property. And after today's webinar, if you're interested in exploring more topics on open source software or standard essential patents, we encourage you to visit our website to find out more materials. I'd also like to mention that in addition to our research and infographics, we also have a case law section where you'll be able to gain a better understanding of sort of the appropriate behaviors for licensors and licensees of standard essential patents in their good faith licensing negotiation. Our database provides summaries of almost all of the European court decisions in this area, so we encourage you to check it out to learn more. And of course, we are on all the social media, and we encourage you to follow us there at 4IP Council. That includes X, LinkedIn, YouTube, and Instagram. And it's a great way to find out about our upcoming webinars, our latest research, and any of the new interviews and podcasts that we produce. So without further delay, it is my pleasure to introduce today's presenters, Dr. Gregor Langus and Dr. Vilen Lipatov. Gregor is Vice President at Cornerstone Research. He is a competition economist who supports clients and provides expert testimony in antitrust investigations, merger reviews, competition damages matters, and arbitration proceedings across an array of industries. Vilen is a principal at Cornerstone Research, and he is an industrial organization economist who consults on competition policy and related issues with an emphasis on multi-sided markets, intellectual property, mergers with conglomerate effects, and innovation. So a final remark before I hand this over is that I encourage the audience to use the Q&A function at any point during the webinar to ask questions directly of our panelists, which we will do as soon as their presentation is finished. So Gregor, this floor, or actually, I guess more accurately, the screen is all yours.
Thank you, Jillian. A small disclaimer that these are mine and Vilen's views, not the views of Cornerstone. So this talk is about a paper that Vilen and I have recently published. It's a pretty long paper, well over 30 pages. And it's not because Vilen or I like to write long papers. To the contrary, even less so, we like to read long papers. But it is because when we try to look at how open source software and FRAND-based standardization, in particular cellular standardization, how they interact, we saw that actually that's quite a complex area, which involves a number of dimensions. Clearly, legal dimension, you have copyright and patent on the other side, but it's also very important to understand and look into the technological dimensions. These are different technologies, different processes of production of knowledge. There are issues of economics, and then there are also issues of culture. And when you start unpacking that, you actually see that all these issues together interact to kind of define or determine how the two models of knowledge production, knowledge advancement will interact, how they will complement each other, when and where they are in conflict, if at all, and so on. And these are the issues that we try to sort of unpack. We'll only be able to scratch the surface here because it's a short presentation, but we do invite you to look at the paper for more and ask questions. So we'll put forward 3 theses. First one is sort of obvious. It seems that open source software and FRAND-based standardization, and we'll focus on mobile or cellular standardization, that these 2 models of knowledge production are complementary. And software generally, either proprietary or open source software and technology, hardware, they're kind of like poster children of complementarity, as any antitrust lawyer, if any happen to be on this call, will know. But I think, and I will try to convince you that there's more to it, to this story. In today's world, especially in 5G and as we move forward. So there is a lot of scope for complementary interactions between these 2 knowledge advancement models. The second thesis will be that the 2 models of knowledge production are largely compatible. That's interesting because not everybody agrees with that, and it's something that we wanted to analyze closely, and we did, and we'll say a couple of things on that. And the third one is that the open source software licensing and development model could not effectively replace FRAND-based standardization, in particular not in the cellular sort of arena. The 2 models, in our view, are not good substitutes in that context. But let me sort of motivate this question a little bit better. Apart from the obvious that OSS and more generally software and hardware feel to be complements to pretty much everybody, and we see that Apple's phone, nothing without many applications. Android, the same thing. Nokia probably failed with its mobile phones at some point because it didn't manage to grow a complementary software ecosystem. So that's sort of obvious. But recently we've seen some other initiatives which have again brought the questions to the fore. In particular, the European Commission's SEP reform. I think many of you have heard of that, where the Commission proposes an overhaul of the standard essential patent framework. Obviously, a discussion which has raised a lot of interesting inputs, some extreme views, and so on. And in that discussion, well, so first of all, European Commission said, well, we don't have quite a sufficient transparency in the FRAND licensing framework. That leads to low predictability for the implementers. They may be uncertain about FRAND terms and so on. So that could stifle upstream, downstream innovation. That was the motivation for this proposal. And OSS community was quite vocal in that debate, stating that, look, we might have a conflict between open source licensing principles, as well as more generally the development model and the FRAND-based standardization model, because in particular, open source licensing requires an automatic grant of all rights. Again, not everybody agrees with that, and we'll look at this, we'll unpack this a little bit, but it's much more in the paper. Second, the OSS community put forward the suggestion that licensing friction stifle OSS development, and that the culture is incompatible with FRAND licensing and development, and urged the Commission and more generally the society to take account of these factors when shaping the framework, as we go forward for cellular standards in particular, but more generally so. So very shortly, and I imagine that quite a few people in the audience will know that, but just to make sure that we're kind of like all on the same page, or at least as much as possible. So the commonality of open source software development is the free revealing of software code advances. In a nutshell, when you are distributing software, you are supposed to also distribute it in a human readable form. But when we look at what open source software is beyond that, we see that actually it's hard to get a comprehensive uniform definition. It's actually what open source is differs from one person to another, and it differs across different contexts. And if you really want to discuss what the interaction is between FRAND-based standardization and open source software, you actually have to consider that there are multiple models there, and that how these models interact, complement each other, and potentially be in conflict will depend on which model you're in. When we think of, the archetypal OSS model, the models that emerged in the 90s, maybe even 80s, in some US universities, we think of group of loosely coordinated enthusiasts who spend their weekends working on a software project, sharing the code, learning, resolving their problems, and so on. In fact, today, many high-value, complex OSS projects are professionally managed, and they do benefit from corporate involvement by firms whose commercial motives are very much at the front of the of what's going on. And when companies originate an OSS projects, well, they do so when they expect that commercial benefits will be larger than from keeping the project proprietary. And I think here a good example probably is Android, which people who've been following the saga and the development of Android will have known. So where do we see OSS? Well, we often see it when in the context of a kind of like some sort of an interoperable commodity software platform, where then companies use it. Well, they make it available, and sometimes for free, and then use that platform to sell complementary services or products, including in the model of a software as a service. We see that more and more as the cloud services develop. Amazon, Oracle, Google, Microsoft, they use open source software on the cloud, and then add to that certain services. Sometimes companies use it internally as part of their infrastructure, and then they make it an open source so as to reduce the cost of advancement and maintenance, basically asking the community, other companies to implement, but then feedback the improvements, bug fixes, and the new functionalities. Another motivation for companies to participate in OSS communities to get access to talent pools, and that's actually useful because coding skills typically are quite fungible. But they also benefit from the active participation. OSS often attracts, especially if it's highly successful, multiple conferences, published materials, and websites, and there are some commercial, maybe not directly direct monetary benefits, but ultimately that can translate into monetary benefit as well. Shortly about what is FRAND-based standardization. Well, it's firmly based on patents, intellectual property, right to exclude, and everybody knows more or less that patents are there to incentivize investment and then the revealing of technology advancements. But an important function of the patent, which I think we need to keep in mind here, is that it also standardizes the way in which the advancement is revealed. And it also limits the scope of the claim. And that in turn, together with the first factor, incentives, in turn helps efficient markets for technology to emerge, both on the side of technology creation as well as on the side of technology implementation. That is true for patents in general, let's say patents in pharma. But when we come to kind of complex standards such as cellular, well, there are some complications. There we have many contributors of many technologies, and sometimes the correspondence between, a patent or a set of patents, its value and the final product is not totally clear. And the other thing, obviously, with standards is that we want to encourage implementation actually before all licensing issues are fully resolved. So what we do, well, we have a FRAND commitment, which sort of ensures that implementers are not going to be approached, held up later on, but they can, implement technology, wait for a patent holder to approach them and ask for the license to pay, and that license will not be, the terms will not be exorbitant, but will be limited by the fair, reasonable, and non-discriminatory terms. That's more or less, I think, kind of generally accepted. And now we're kind of moving to our first claim, that open source software and FRAND-based mobile standardization are complementary. And as I said earlier, that's true generally for software, either proprietary software, so software which is distributed in a binary, non-human readable, non-readable code, but it's also true for open source software. And I think what's changing now is that, as we move from 3G, 4G, and 5G, the cellular system is becoming more and more like a large distributed compute and communication platform, unified to some extent, or increasingly unified, which comprises a lot of hardware and a lot of software. So you have mobile devices, you have multiple sensors, a multitude of sensors in the IoT world. You have connected cities, you have the cloud, the storage, you have content that is dynamically shifted across the world, and it all has to somehow live in an integrated world. What we see is, system that is pervasive. It connects people to people, it connects people to content, it connects machines to machines. That's the vision, and in part it's already being accomplished. That is to say, both proprietary and OSS, open source software, will play a key role in that system, and they will play a key role in its adoption and in making it efficient and effective. But let me switch. So you see, this is sort of like a high-level representation of this system, and software, be it proprietary, open source, is pretty much on each part of the system. But what's happened in the last iteration of the standard, so as we move from 4G to 5G, even more so from 3G to 5G, is that there have been very significant innovations in the architecture of 5G, and these innovations are necessitated by the high requirements for this new standard. It needs to sort of serve extreme bandwidths, it needs to be highly reliable, and it needs to connect many devices across the board. And that necessitated some sort of new approaches, such as software-defined network, virtual network functions or network function virtualization, which in turn necessitated an increased modularity. So what we had before was kind of like closed systems, a lot of it hardware and proprietary software, which are now being increasingly modularized, which introduces the scope for independent third-party software vendors, both proprietary as well as open source software. Even in the parts of the network, such as radio access network, where before you had really a lot of sort of proprietary package solutions. These are now being modularized and virtualized. More so is in the configuration and service orchestration software, which is part of the core network, where firms, operators introduce services such as network slices, which what these network slices do is they define a service and then allocate it to the users, and it's defined in software and dynamically scaled up, scaled down, depending on the needs. And that's where third-party, proprietary, as well as open source software can actually enter and have entered in the past. And that's a very active area where open source community is highly active. Now, in a nutshell, what we want is a combination of proprietary and open source software models working in parallel or at different levels or components of the system. And these innovations in the architecture have enabled that. Now, this is sort of our second claim, that contrary to some suggestions, in fact, what we see in practice, and when we look at some of the legal details, that open source software and FRAND-based standardization are in fact compatible. And how do we see that? Well, first, in practice, we see that open source software is pervasive. It's really incorporated in many sophisticated products where there's thousands of software and hardware patents with which this software interacts. And most kind of obvious example are some operating systems, Linux, Android, which interact with hardware as well as other software patents. And if we really went as hard and say that, if we really went all the way and say, look, this model is not compatible, well, that could in principle undermine the patent rights well beyond the software itself and break the system. If we insist that OSS licenses are not compatible with patents, I think that would actually put into question, even the software and hardware combinations that we've seen for decades, if not more, such as Linux, Android, and other software. But when you look at kind of the legal implications, and here we refer to, to legal analysis. We're not lawyers, but we did carefully study the literature. And what you see is that some copyleft licenses, these are licenses which are sort of most extreme in terms of the requirements in relation to giving all the rights that could be implicated in the software, in fact, do not imply a patent grant, and or patent grant held by third parties. Other types of OSS licenses are compatible with payable patent royalties, and there is a family of open source licenses which are incredibly permissive and fully compatible with payable patent royalties. This is something that we unpacked in the paper, and we don't think we can spend much more time on that. So if you look at what happens in practice in the cellular standardization environment, you can see that in fact, open source software is alive and well, even in the parts of the cellular system, such as radio access network, which is most heavily patented and probably most crucial for compliance with standardization, because it relates to how devices communicate with antennas, base stations, and vice versa. Even there, you have, I see, so we have to speed up. Even there, we see that that open source software is actually successful. An example is OpenAir interface, which is a stack for the interface on hardware, which is basically available off the shelf, and software-defined radio cards. So today you can in fact implement some of the 4G and 5G functionality on software-defined radio cards, which you can buy off the shelf. And there, the software does implicate potentially high-value patents, as I said. Initially, this software was licensed under a extreme copyleft license, GPL. But then the community realized that there might be potential legal implications, so they issued it under custom public license, which explicitly foresees FRAND licensing. And contrary to what people would have expected, maybe, in fact, we've seen that not only did this stifle, not that this did not stifle further development, but in fact sped it up. And this community features a lot of tech firms, a lot of SEP holders, open source software firms, etc. This is kind of like a high-level representation of the community of the OpenAir interface. More generally, open source software thrives in this environment. As I said, when you are building out new generation networks, you want to introduce new concepts such as network function virtualization, and that requires software which allows for a flexible management and orchestrations. Open source, Mono, and open network automation platform are two examples of such solutions. They are open source and the community is alive and well. So these are the two first theses. I'm going to now turn to William to explain the following question. So we've seen that OSS can coexist and complement a FRAND-based standardization, but nevertheless, there might be some remaining frictions, either legal, cultural, or maybe just licensing frictions. So one might still ask the question, well, fine, maybe it's all good and well, but perhaps it would still make sense, or we could still even make it even better if we replaced the FRAND-based development of cellular standards with the OSS licensing and development model. And William will now take over and explain why we think that this would not be a good idea.
Yeah, thanks, Gregor. So we think there are a number of reasons for that, and we encourage you to read the paper for the whole list. Because we have very little time left, we'll just discuss three of them. First one is intrinsic motives, mostly relevant for archetypal OSS models, as Gregor discussed them. Then the second thing is size of incremental advances in knowledge production. And the fourth one is a free rider problem. So about intrinsic models, intrinsic motives, why do we think they are a bit different between OSS environment and standardization or mobile standardization? After all, it's intrinsic and something that lives inside you, so there shouldn't be any difference. Well, psychological research shows that these intrinsic motives, they are not entirely intrinsic. They thrive in certain environments. And so what keeps us motivated, apart from what you find, that you find the work interest and you're serving a good course, is first the prompt and positive community feedback, and second is a sense of autonomy and self-determination. Maybe the terms are self-explanatory, but just to reiterate that prompt feedback, it means that you get prompt reward of your efforts in terms of recognition from peers. And here you can see that in OSS environment, feedback is almost immediate. So you write a piece of code, you send it to GitHub, and somebody approves it within hours. With standard development, that may take a long time. Then the sense of autonomy is also much larger in OSS environments. You can choose from a myriad of OSS projects and plan when and how you work on your task independently. You can be a digital nomad and work from home. It's a very modularizable environment, as Gregor also pointed out. So it's much less so for a wireless engineer. They need to tightly coordinate working schedules and often cannot work from home because they need to be physically present in the lab. So the second thing is the incremental advances. Why are they small in OSS? Again, we come back to this modularity and this fast feedback loop. So the tasks can be distributed among various community participants. Even users can often provide bug reports and fixes. And then there are distributed code management platforms such as GitHub that facilitate this distributed development process. Moreover, bugs even easily fixed after implementation. Finally, software developers get a nearly automatic copyright grant. So, and this we need to compare with the cellular standard environment that requires large teams for development and design, highly specialized fundamental research, prototype buildings that can be very costly, both in terms of money and time. So what you can imagine as debugging in standard specification, it's totally impossible after implementation is already made. So, and finally, the patents are much more costly, or in principle, costly to obtain and enforce, where compared to automatic grant of copyright. So why does it matter? Why do these difference in advances, in incremental advances matter? That matters for incentives to invest into this knowledge production process. So small advances, they are easily monetizable, and so they are in OSS context. So for example, you can do complementary services sales, or you can go to a firm that would reduce the cost of its IT infrastructure on the basis of OSS. And you can charge for commercial use of OSS. It's hard to find something like this for cellular standardization, because you need highly specific knowledge and investment, and a long time, high costs to get to incremental advance. You practically would need to integrate with a final producer in some market to be able to monetize on your effort. I'm almost run out of time, but I still want to talk about the free riding problem. So the free riding problem, I think you all know about it. But just to make sure, it's, suppose Gregor would have written this paper, prepared these nice slides, and I would come to this presentation without doing anything and made just a slide karaoke. There would be a free riding on Gregor's effort without giving him any recognition. Why doesn't it happen with us? Because we frequently interact, because we work together, we build some trust. We will have another project soon where we will again have to contribute. It's very similar in OSS environment. So you have frequent interaction. You have, again, relatively low cost of incremental advances. You have prompt implementation, and you have this fast quid pro quo cycle between downstream and upstream developers. Basically, you see, even when the users can fix the bugs, and then, yeah, next time somebody, you have certainty that you will be reciprocated in this process. The standard developers wouldn't, like, without FRAND licensing or without some patent, the competitors on the downstream market would just grab this technology if it were for free, right? That would be a free riding. And so we need some kind of patent protection, and FRAND seems to be a very good deal in striking the balance of interest of implementers and innovators here. So yeah, I'm over time, but just to repeat that we don't think it's a very good idea to bring the OSS licensing mode into the mobile standardization for 3 main reasons. You just heard, and there are more reasons you can check in our paper. Thanks a lot.
Thank you, Velin and Gregor. I know it is a challenge to be asked to produce such a short presentation on such a comprehensive paper, but I think judging by the Q&A, you have piqued people's interests, and I do hope that they go and find the full paper and read it after this presentation. But we do have some questions coming in, and I encourage the audience to continue to put those into the Q&A. And we will get through as many as we can. We only have 20 minutes, but we'll do the best we can. So I think to start things off, you know, you mentioned that FRAND and OSS licensing are complementary, but did you have in mind any specific synergy between the two approaches? Do you believe that the benefit is actually larger when they're both combined than when they're used separately?
Yeah, so I spoke about the general compatibility of software and hardware, which is intuitive to everyone. But what's happening right now? There's 2 things happening. First is that we are building a cellular system, which is essentially a huge distributed IT infrastructure, something that in the past, you know, was sitting on a server in some room. Now it's actually distributed across the whole world. We have compute power on a mobile device. We have it in antennas or base stations. We have it in the edge, in the cloud, and then that connects to servers, AI, and so on. So everything is sort of brought together by cellular and other technologies. So naturally, this expands the scope for both proprietary and OSS software. But what is what is then in addition? What does OSS software bring in that environment? Well, it's a little bit different model than proprietary software model. Originally, the open source software was conceived as the idea that, okay, I'm going to make this software. I'm going to share it with, my colleagues at the university, and they're going to feed back some, solve bugs, and we're going to all learn. And you're bringing that to the new environment as well. So that is, the benefit of it, the new idea. You also have companies now that can read, modify. Users can fine-tune their software to their needs, and that cycle then can be repeated fast. It will not work in all parts of or it will not work ideally in all parts of this new environment. In some parts, we will want to see proprietary model. In some parts, we will want to see an OSS model. But both in terms of, the overall size of the compute, importance of this compute environment, as well as in these special features of OSS, I see that there is this, new additional complementarity that OSS can bring. I think you're on mute, Gillian.
I certainly am. Thank you. So let's go back to the distinction between patents and copyright for a minute. What role do each of these play in ensuring the effective development of cellular technology versus?
Yeah, I think that goes back to some of the things that William said, right? Copyright is sort of automatic. You write 100 lines of code and, with little more, you have a copyright. Patent is very different. If I write a code over the weekend or a piece of poetry, I'll have copyright. If I make some advancement, not that I can, but let's say in wireless, I'd probably have to spend like 6 months trying to patent that, probably hire some patent lawyers, and then I'm not even sure I have a patent. So I don't have any right to claim, or at least it's very uncertain. And if we go back to the environment, a new iteration of a standard, it's about 3 to 5 years. Even if I have a really good idea, I have to wait for 3.5 years to be included in the next iteration. If the many stakeholders agree, chances are they won't. And even if they do, chances are that on that patent, there will have been 10 people. There's a lot of money that we'll have invested. So that's another part which, you have to take into account when you're considering these models, the nature of advancement of technology and the right that I get, copyright, creative expression versus patent, technological advancement, well described, horde of lawyers, and uncertainty around it.
Okay, well, building on that idea of the sort of complexity, there are a lot of integrated innovators in the mobile telecommunications space, a couple of large ones based in the Nordics perhaps come to mind. Why wouldn't a player like that simply increase the price of their equipment by the value of their IP to continue the level of innovation without sort of the hassle of FRAND licensing?
Yeah, that's a good question. And probably they could just do that if they didn't have FRAND protection. However, technologies that are protected by such firms, patents, are not only used in its own equipment, right? But also in equipment or some chipsets, components of its competitors and complementers. And without FRAND, each chipset producer or producer of such complementary or competitors' equipment would have to base its innovation decision on expected profitability of their own product only. That could lead to underinvestment. And like in a worst case, even wasteful competition of standards when we don't have like really standardization and acute free riding problem.
Phil, and staying with you for a second, I'm hoping you can kind of unpack what you mean by incremental advance a little bit more. Do you have a definition? How do you measure that increment? And how are you sure you don't apply different standards in the case of software versus sort of communications technology? Could you unpack that concept a little bit more for us?
I try. So I mean, I have to be nitty-gritty here if I want to unpack that. So please, like, welcome follow-up questions if some terminology is not clear here. So we think of incremental advance as something that characterizes the minimal size of investment after which the advancement may be published and subsequently marketed or get patented in a proper content or copyright in the context of software.
Incorporated, right? Incorporated in a product.
Right, exactly. And we think a pretty objective and consistent measure for such an increment is all the costs incurred to bring this contribution to the state of being incorporated in the product. And I guess that will mostly be labor cost and capital equipment cost, but maybe some other as well. And as such, it is exactly the same approach to cost counting that can be used in the OSS content, where hours of the coders, the laptop that they use, and compare it with hours of engineering researchers with their PhD degrees potentially, and testing equipment, prototype building, raw material costs, and things like that.
But can I add something to this? So this is not at all to say that that OSS coders are not amazing and they're not advancing the knowledge tremendously here. What we're saying is that advancement is fast-paced, much faster than generally in, for example, context complex such as complex standard, but also the increments are typically smaller, not always, but or at least can be made smaller, right? You can really effectively distribute the development among many coders. If you look at Linux, I mean, it has more than 10 commits of code. So, new additions of the code into official distribution per hour. It's just like, it happens in real time as we speak. Linux has advanced significantly, maybe, but in small increments and very fast paced ones. That's kind of like, the nature. There's much more, and it's a subtle question. And in fact, you need to really unpack it carefully. We cannot do it here.
Okay.
But we've tried to do it in the paper.
Okay, very good. Well, thank you for giving us a little bit more of insight into that. So we have another question here, and it says, do you think it matters for compatibility and complementarity where the open source implementation of a cellular standard would happen? For example, if it is hosted inside the SDO where it is standardized or hosted outside of it?
So, well, that's a tricky question. I don't think that either of us is, extremely well placed to answer this question. It's not something we've analyzed in the paper. We know that there are certain projects, OSS projects, which are hosted, for example, by Etsy, but they are separate from the standardization effort. And they're separate on purpose in order to limit the potential for conflicts, legal conflicts, cultural conflicts, in order to have some inadvertent implications of what is done in the software on what happens in terms of the development and patented technologies that go into the standard. So I think that's probably not a great idea to kind of like bring this together right now. I don't think it's going to happen. I think both for many reasons, in particular, lawyers will push back, and lawyers probably have good reasons for that. But then, yeah, we are not. I think we're not there yet. It doesn't mean that people are not thinking on both sides of the fence. A lot of people are thinking how to actually build an ecosystem which brings these two things together. And as I said before, look, if you have a patent and you're concerned about, frictions, licensing frictions, well, you should be much less concerned when it comes to FRAND encumbered patent, because FRAND is aimed at minimizing these frictions. And open source will interact with patents generally, and it does, and we don't see a big problem. I do not expect, or I expect much less of a problem when it comes to to FRAND encumbered sort of patents, because they already have inbuilt some of the safeguards which kind of minimize a potential for tension.
Right, thank you. Well, I'm going to make one more call for people to raise questions in the Q&A function at the bottom of your screen. I think we have a couple of extra minutes here today. So Willem and Gregor, would you like to make sort of a closing statement of a few minutes, just to sort of round out what you really want people to sort of take away from the paper, and I guess give them the teaser so they can go download and read the full paper?
Willem, do you want to go first? Okay, so I'll say that this is exciting. What's happening now is exciting. I've been to recently to a lab of wireless company, European wireless company. And, what I saw there was just totally insane. So, there was a representation, a digital representation of a world, but there were people, including me, there were machines, and you could see that on the screen. And what happened in real time is, the information was fed into the system. The information anticipated what people will do. I don't know, take a car. Car is coming. A person walking and intending to cross the street. You now have a digital representation of the car and of the person. And the system, cellular parts, the cloud, the whole system kind of anticipates what's going to happen, sends the warning to the car or to the person operating the car, stops the car. That's actually real already. We just need to build it out. OSS, proprietary software, and people contributing these technologies, in radio access network and other parts of the system are going to play a big role, and they're going to continue to collaborate. I don't see, that this is an issue, and I'm looking forward to seeing what happens next. Excellent.
Well, I think in a rather unusual fashion, we'll be able to sort of wrap this up and potentially give people just a few minutes back. I want to thank everyone for attending today. A recording of this presentation will be available in the coming days on our website. You'll also be able to find the paper on our website. And we really want to encourage you to register for our next upcoming live webinar, which is taking place on the 23rd of November at 3 p.m. Central European Time. And this is a collaboration with IPAN about the IP landscape after Brexit. And you can find more on that QR code you see on your screen now, or as I say, on our website under webinars. I want to thank Gregor and Willem again for being here and presenting our paper, and for taking all of the questions that you all have raised. And final note, I want to remind everyone that you will receive an email inviting you to complete a 1-minute survey about this webinar. And we'd be really grateful for your feedback, because we're always looking for ways to make them more interactive and more useful to the audience. So thank you very much for attending today. Thank you and goodbye.
Thank you, Gillian. Thank you for IP Council.
Thank you.